Okay, are we ready to go?
Yes.
Is everybody in? Mahendra, are we ready to go? Is everybody in?
Yes. We start.
Start. Okay. Okay. So, very good evening to all of you who are joining us today for this webinar. And let me first begin by introducing myself. I'm Sanjay Nagral. I'm a surgeon. I work out of hospitals in Mumbai. I also chair the Forum for Medical Ethics Society, which is the host, one of the hosts of this seminar, along with other platforms, which include the Indian Journal of Medical Ethics, which is the journal which this the forum runs, and the Health Ethics and Law Institute, or otherwise called HEAL. We are today also have the privilege of having with us the Department of Medical Humanities, which we shall talk about of the KEM Hospital. But before that, let me also invite my co-chair, or the I would say the coordinator, the actual coordinator of this meeting, the most effort, Sumana Naveen, who after a long stint in organ donation has now joined us in the ethics movement. Welcome. Sumana, would you like to
Medical Ethics Society.
say something? Are you there? Are you going to say something?
No, Sanjay, please go ahead.
Okay, thank you. We would just we have a longish program and ahead, so we would rather quickly jump into it, but it would be appropriate to share a few words to those of you who don't know the FMES and IJME about what these organizations are about. So the Indian Journal of Medical Ethics was started as a small little small publication in Mumbai's KEM hospital way back in the early 90s, 1993 to be precise. But over the years has grown into what perhaps now is the leading journal on medical ethics, or rather bioethics from South Asia. Is there some disturbance? Is there a way we can reduce the disturbance? Can somebody do that? Just to therefore come back to what I was sharing with you, the journal is now almost 30 years old. It's indexed journal, indexed in most databases, including the National Library of Medicine. And around this journal actually has grown a platform. And this platform is the larger platform of bioethics in India. Both the Forum for Medical Ethics Society, which is the umbrella organization, the HEAL, which I mentioned to you, and also a meeting which we hold every 2 years, what's called the National Bioethics Conference, which brings together a large number of individuals from various disciplines in India to meet and discuss about the emerging bioethics challenges, especially those relevant and specific to this part of the world. I just want to end by saying that the group is, whilst it is now a strong academic commitment and as an academic journal, but actually is rooted in the day-to-day struggles for better healthcare, for access to healthcare, for healthcare for the vulnerable in this part of the world. And as many of you know, that it is one of the major challenges that our citizens face. And we have in the past also been engaging with groups in India which are engaging, which are working very, very seriously for a long time on the area of end-of-life care. So with this brief introduction to the FMAS, the IJME, I would now like to invite Padmaja Saman. Padmaja is a gynecologist at my alma mater, the GS Medical College, KM Hospital, Mumbai. But of course, she's here today as the coordinator of the Department of Medical Humanities at that college. And I welcome Padmaja and request her to say a few words about their department. Padmaja, please.
Thank you so much, Dr. Nagral. And yeah, can you hear me?
Yeah.
Hello?
Yeah, there's a bit of a, but go ahead, yeah.
Yeah. GS Medical College, Division of Medical Humanities, and Dr. Manu VL Kothari, Chair of Medical Humanities in our college. And there in the meeting, Dr. Sunil Pandya, Journal of Medical Ethics, is the chair of medical humanities in our institute. And this division was started in January 2015. And it MBL Kothari, who has been who has been inspiration behind this.
Padmaja, I think we're losing you. I think we are losing you periodically. Mahendra, are we losing her?
Yes.
Right. So, Padmaja, we have lost you, but if there's a quick way you can reconnect, or otherwise we may have to get on. Mahendra, any way we can quickly connect with her? I'm unable to hear her. Can you?
No, we can't hear her either, Sanjay.
Okay.
So I think we'll move on.
Yeah, absolutely.
With the first speaker. So if you could please introduce Dr. Paul McConnell.
Sure, absolutely. So, as is obvious in the backgrounder and the title, the webinar today attempts a deeper dive into a case called the Archie Battersbee case, and of course we will know more about it. But it's I guess a vehicle to take a dive into the entire area of end-of-life care and the challenges around that. And essentially, this webinar has been roughly sort of divided into two parts. In the first part, we have two of our colleagues from the United Kingdom who obviously, are from the place where this case played out. And the first speaker is...
Hello?
Yeah, Padmaja, I'm sorry we lost you, but we are getting on and we'll get you back to talk a little later. Yeah, Padmaja, we are getting on with the webinar. We will get you back.
I'm sorry.
No,
the connect.
Yeah, I know. That's all right. We'll get back to you. So the first speaker.
Go ahead.
Yeah. The first speaker today is Dr. Paul McConnell. Paul is an anesthesiologist by training, anesthesiologist and critical care specialist. Works in Scotland out of the Royal Alexandra Hospital. But he wears another hat, which is a hat which is his interest and training and in ethics. and Law, and he chairs the Ethics Committee of the European Society of Anesthesiology and Intensive Care. And he's actually formally trained with a master's in healthcare ethics from the University of Manchester. So Paul is going to speak to us on the Archie Battersbee case. Perhaps he will be taking us through some detail on what exactly the case is about and give us his perspective. So welcome, Paul, and please go ahead.
Dr. McConnell, I'll stop share so that you can start.
There we go. Can everyone see my presentation?
Yes.
Lovely. Thank you so much for asking me to speak here. It's a real pleasure and an honour, and I'm looking forward to learning from all the experts that we've got here as well. So I'm going to speak to you about the Archie Battersbee case. Now, this was a tragic case that happened in the UK, but a lot of the themes that it brings up are not actually unique. And that's why I think it's actually very important that we consider it. So I've got a brief timeline here from what happened. So Archie Battersbee is found unconscious with a ligature round his neck and taken to hospital. From this point, he never regains consciousness. On the 26th of April, the hospital begins legal proceedings to allow brainstem death testing to be undertaken after parental refusal. Now, that's quite important, and that's something we need to come back at when we look at the timescales involved here. The court rules that brainstem death testing should be carried out on the 13th of May. However, these could not be performed as Archie did not respond to a nerve stimulator. Following further liaison with the court authorises MRI scanning despite parental objections. In this case, the objections being that the parents felt it was too dangerous and would be to a harm to move him to the MRI scanner. And on the 31st of May, Archie is declared brain dead based on MRI evidence. Now, this takes us then to the 13th of June, where the court then rules that Archie is dead and therefore life-sustaining treatment can be withdrawn. The family launch an appeal on the 20th of June. The Court of Appeal looks at things and determines that the MRI is not a suitable choice for declaring him brainstem dead. And as a result, a new hearing is required to determine what Archie's best interests are. On the 15th of July, the High Court rules that life-sustaining treatment should be withdrawn on the grounds of futility. A further appeal is launched to the Supreme Court. However, that appeal is rejected on the 2nd of August with a heavy heart, in the court's own words. And on the 6th of August, life-sustaining treatment is withdrawn and Archie is declared dead. Now, this played out across both the national and international medias with lots of different and poorly informed takes on the story. But let's consider things. What are the key issues this brings up? Well, the issues are: how do we define death? How do we define futility? What are best interests and who defines them? What is the role of parents in these cases? And in these cases, is conflict actually inevitable? So let's think about defining death. Now, all of these individual topics could be lectures on their own. But I think the easiest thing to say is actually, it's more difficult than it seems. And nowadays, with ECMO and organ support. Oh, if somebody could just maybe mute their microphone, there's a lot of feedback there. The UK has 6 tests, none of which include imaging, and they were not able to be performed in Archie's case. Now, the gold standard, if we're using imaging, is 4-vessel cerebral angiography for declaring brainstem death, but it's still an ancillary test. And while MRI is more accurate than CT, it's still not recommended. Now, interestingly, speaking to a lot of healthcare professionals, they felt that what was shown on the MRI was enough to declare brainstem death, but it isn't within the UK's 6-test criteria. And even in America's criteria, imaging is still ancillary. So perhaps if there's one lesson to be learned from this case, it's, do we need to rethink our criteria or even our basic definitions of what death is? That's becoming even more important now when we think about things like ECMO and other forms of organ support. What about futility? Well, I call it the F word, because you shouldn't mention it in polite ethical discourse. It's a really poor choice of language. Nowadays, we tend to say medically inappropriate is better. But we've known about the concept of futility for millennia. Hippocrates even talked about those who were overmastered by their disease. But the trouble with futility is it's highly subjective, and it ultimately comes down to the values of the patient or the family or the doctor or even society. It can almost be like a sort of club rule that we all either agree with or then disagree with. And when we disagree with it, that's when problems happen. So Beauchamp and Childress, actually more famous for their 4 pillars, also talked about 4 possible states of futility. They obviously thought 4 was a really good way to classify things. So they talked about 4 possible states. The first being the procedure cannot be performed due to the patient's biological state. Okay? You can't do anything about a decapitation. It's that level. Second is the procedure cannot produce the intended physiological effect. Well, we can maybe put a tube down, but actually their lungs are completely honeycombed. We can't actually ventilate them. The third is the procedure cannot produce the benefit that is sought. Well, we can produce oxygenation, but is that actually all that we're interested in? And the fourth, that the procedure's burdens, harms, and costs outweigh its anticipated benefits. And that's quite interesting, because what we've done is we've gone from a fairly absolute state of futility to one that is very much subjective and qualitative. We've gone from objective to subjective. That seems an odd way of saying this, but this is something that the UK courts and ethicists have become very focused on. Now, can we actually have a quantitative approach to futility? That would make everything much easier. You know, we are scientists. We want to be able to measure things. So Schneiderman advanced this idea that a treatment is useless if it's failed in the last 100 patients. But what have we done? We've essentially just shifted the goalposts there. We've defined futility, but now we've not defined uselessness. Okay. And what are we going to say? Does useless mean it's a treatment that means that the patient isn't alive at 5 years? Isn't alive at 1 year? Is it useless if it doesn't change the time that they're alive, but makes them more comfortable? It's all quite unclear, and therefore the idea of futility is not a great one. Now, one of the principal cases in the UK that dealt with this was James v. Aintree. Okay, that happened in 2013. Following a prolonged ICU admission of greater than 12 months, the hospital sought permission not to further escalate support in a minimally conscious patient. And that's actually important. They weren't even talking about withdrawing at that point in time. They were talking about not re-escalating care. And the family opposed this. Now, this went through most of the courts, starting the Court of Protection and finishing in the Supreme Court of the UK. A doctor cannot be forced to provide a treatment that is not clinically indicated. That was established in Burke. But a treatment is not futile if it brings some benefit to the patient, even if it has no effect on the underlying disease or disability. Taken to its extreme, Baroness Hale even talked about things like aromatherapy here, that it actually brought some benefit, made the patient feel better while having no overall medical benefit. And key here was that recovery does not mean a return to full health. It means the assumption of a quality of life that the patient would regard as worthwhile. And a patient's best interests then incorporate not only their medical interests, but also the patient's welfare in the widest sense. From Aintree, some of the important quotes were, the starting point is a strong presumption that it's a person's best interest to stay alive. But they did point out that wasn't absolute. They went at lengths to say recovery does not mean a return to full health, but to a quality of life that James would regard as worthwhile. But all this patient-centeredness was tempered with this caveat. That is not to say that his wishes, James, must prevail, any more than a fully capable patient must prevail. We cannot always have what we want, nor will it always be possible to ascertain what an incapable patient's wishes are. So this brings us then to best interests. There is a lot of literature on this, but there's something very important that we have to remember. When to seek best interests is actually really well defined. Who to seek them from, and more importantly, the weight that they are to be given, is less well defined. But if you look at all the UK acts, the Mental Capacity Act, best interests specifically are barely defined at all. So what does that mean? Well, actually, it means that everybody is sure that they're working in the patient's best interests, but nobody might agree on what they actually are. Now, the Battersbee case had an extra emotional dimension to it because of the young age of Archie. Okay. So let's think about the role of parents. Well, parents do not have any rights in the classical sense, though that is not helpful to point out. Okay. Patients instead have a set of obligations and duties to their children, and their special status actually allows them to fulfill that. Parents are not entitled to insist upon treatment by anyone which is not in their child's best interest. And medical teams must also act in the child's best interest, albeit that will be weighed by a medical bias. Interestingly, though, the court cannot force a doctor to act in a way which breaches their professional conscience. This is returning to the case of Burke. So what does that mean? Well, the parental rights are always going to be subordinate to the paramountcy of child welfare, but a doctor can't be asked to act contrary to their clinical judgments. So parental wishes are not judged on reasonableness or the impact on the larger family dynamic, but rather solely on the best interests as defined by the court. And as medical teams and judiciary move on, the parents will always be left to bear with the consequences. So they talk in child health cases about the paramountcy principle, okay? So all judicial decisions are framed under a banner of welfare, which is deemed to be paramount, okay? But this is a big problem. It assumes that the child is the most vulnerable person involved in this, and the paramountcy position will erode any position that parents might take. As quoted from Rees, the strength of the paramountcy principle is its apparent neutrality. Everyone can pay lip service to it, but at the same time, it can be used to justify any decision. It's for the welfare of the child. We then need to think in Archie's case about the idea of imperfect obligations and best interests. So healthcare law in children in the UK is governed by best interests. So that means there's a pretty low bar to invoke the sweeping powers of the court. And of course, once the court is involved, there can only be one outcome, the best outcome by definition. There are no shades of grey in the eyes of the court, and that's a big problem. Parental obligations, you see, are imperfect, and therefore they prime parents to go beyond medical advice. They have to be the best parent. They have to do all they can do, whereas our professional obligations are defined. Does this mean we should use a different threshold, significant harm or reasonableness? I think in these cases, the thing that a lot of medical teams lose sight of is that parents do not intend to undermine professional expertise. Rather, they seek to go to extraordinary lengths to fulfill their responsibility. And we can see then why conflict arises, okay? We have a difference in priorities. Healthcare professionals prioritize good care based on biomedical models. Families view good care as being holistic, okay? Very regulated when it comes to healthcare professionals' view, but communication and inclusion is what counts with families. So what were the primary grounds of the parents in this case? Well, that there should be a presumption of prolongation of life, that Archie's previous wishes and feelings should be considered, that Archie's religious beliefs should be considered, that the family's wishes and beliefs should be considered, that Archie in himself does not experience pain and therefore continued support is not a burden to him. And that's probably the one that I actually have the biggest problem with. That there is a benefit to a natural death and that there still might be a prospect of recovery. So there were a lot of important quotes on this. Okay. I think what was important for the court and Justice Hayden, though, was how central Archie had to be to all of this. A reminder that he is not simply who he is now, but he is also who he has been throughout his short life. That they would consider his best interests in the context of a young man who believed in God. And that third quote there, I wouldn't want to leave Mum, I would try to get out of bed. That was actually a quote that Archie had said to his brother previously when they'd been talking about somebody they knew that had been in a serious accident and was left very disabled. It was interesting as well that the courts did acknowledge the role of healthcare professionals. It was upsetting to look after someone who they knew had an irreversible injury, and sadly every intervention feels futile. So the appeal that was launched was that the judge failed to give adequate responses in relation to the European Convention of Human Rights, Article 8, that's a right to self-determination, and the Convention of the Rights of Persons with Disability, Articles 10 and 12. There was also a failure to weigh Archie's previously expressed wishes and a breach of Convention 2 of the European Convention of Human Rights, and that's the right to life. The fact that people were making this decision was in breach of the prohibition of substituted decision-making, and that there was also a breach of the Convention of Rights of the Child, Article 6, which again is to do with acting in best interests. They alleged there were factual mistakes in the pronouncement of failure to breathe and no hope of recovery. And they said that the ongoing treatment was neither futile, burdensome, nor a compromise. And most importantly, there was a failure in the strong presumption of prolonging life. The outcome of the appeal, though, was that all grounds were rejected. And we can maybe go into a bit more detail on that in the discussion. Interestingly, though, by the 10th of July, both parties accepted that the central issue was about the timing and manner of Archie's death. The court then weighed two options. Option one was life-sustaining treatment could be withdrawn at an arranged time, which was favoured by the hospital. And option two, that life-sustaining treatment would continue until Archie's body may give up and he die naturally at a time chosen by God. As we know now, Archie Battersbee had life-sustaining treatment withdrawn, and he was pronounced dead on the 6th of August, following the withdrawal of life-sustaining equipment. So what are some lessons and thoughts going into our discussion then? Well, when brainstem death testing was not possible, should this always have been a best interest decision? It looks from the long gap between brainstem death testing and his admission that there already was communication difficulties and conflict had arisen. Had the staff actually hinged on the idea that a brainstem death test and a diagnosis of death would be neater than getting into best interests? And did that exacerbate things? Was there any move for external mediation employed prior to court involvement? do we need to rethink our definitions of death? Was there any way to avoid conflict in this case? And something we've not gone into, but what is the actual role of media and society in these cases? I think that's a lot to think about. I look forward to having some questions and some discussion on this.
Thank you, Paul. And of course, you have indeed raised lots of questions, very challenging ones. Now, before I go ahead and invite the next speaker, Mahendra or whoever is in charge, please try and see whether you can close everyone's mics if there is a way to control them, because we are getting the periodic disturbance, if that's possible. Okay, so let me now invite the next speaker in this part one, and that is Dr. Radha Sundaram. Radha is again a anesthesiologist turned intensivist, works again out of the Royal Alexandra Hospital from Scotland, but she's done her basic training in India, so and she visits India regularly, so she has a sort of sense of the quite a significant difference in the healthcare in the UK and in India. Radha has also been interested in organ donation, and whilst in this case, obviously the focus was really nowhere on organ donation, but I'm sure this is the link that could come up in the discussion. And Radha has been working with the NHSBT, the Scottish Government, and the Kidney Research UK, especially in improving awareness about donation in multi-ethnic communities. So Radha is going to speak to us on end-of-life care in the UK, and welcome, Radha, and please go ahead.
Thank you. Can I share now? Yeah.
Yes, please, Radha.
So thank you to just taking a little bit of time. Yeah. Thank you to Sumana, Sanjay, and Sunita for inviting us. Paul is a very tough act to follow, and I know this from my bitter experience in ICU when I've followed his ICU weeks. So I'm just going to give you a sort of whistle-stop tour of how end-of-life care is organized in the UK. And I won't labor this point because I know I'm speaking to the converted, but the birth of the NHS in 1948 promised that free care would be given from cradle to grave. But there wasn't that much attention on the dying. However, even at that stage in the 1950s, there were a couple of seminal reports that actually talked about looking after the dying. And this led to the development of the Marie Curie nurses, and Dame Cicely Saunders, the founder of modern palliative care medicine in the UK, started the St. Christopher's Hospice, and palliative care medicine was recognized as a specialty in 1987. And by 2008, we had a network of hospices, of palliative care teams in hospitals, daycare. And Dame Saunders was really important because she didn't want patients to be defined by their terminal diagnosis. And one of the things that she said was very profound, that she would want to do everything she could to help people die peacefully, but also to live until they die. And certainly, as we're moving away from palliative care just for cancer to chronic heart disease, chronic neurological diseases, we do realize that the trajectory or the predictions about when death will happen are no longer as linear as with cancer. The evolution of palliative care has grown beyond cancer in the UK, and there's palliative care teams that are involved in end-stage renal disease, COPD, dementia, HIV, and they do look at all the domains of care. And this care is organized across various settings, community, inpatient hospital beds, and daycare. But the transitions of care, when patients move from one area to another, are often not that great. The key points are that the demand on palliative care is increasing. The funding, interestingly, is actually a mix of charitable and statutory money. So the state does help, and the state's really responsible for deciding a lot of the policy in consultation with charities, but 70% of the funding for terminally ill patients comes from charities in the UK. There still remains a huge inequity in the provision of specialist palliative care across the country. It's a postcode lottery. If you're in the south of England, you're better off. And if you're older, you're more disadvantaged. And if you're from one of the ethnic minorities, I'm sad to say, your access to palliative care is less. We also know that patients, once they're over 75, often spend their last year in hospital. And that means that they may not actually die at home. They may die, or in a hospice, they may die in hospital. And so there has been a lot of work by NHS England to try and coordinate these with electronic records, with encouraging GPs to do advanced care planning, and to actually have care bundles that will recognize the dying patient. But recognizing dying is also not that straightforward. And often when we do, and Paul will confirm this, often when we do our acute medicine rounds in our hospital, with increasing frailty, with increasing number of elderly patients, it's often not very clear to us when the actual terminal event is going to happen. But again, we have to navigate that by actually expressing our uncertainty to the families. We know that 80% of the deceased in the UK actually do spend part of their last year in hospital, but actually by improving palliative care in the communities, allowing people to die at home. And this seems to be a recurring theme in the UK, where when patients are surveyed, they would like to die at home. And the Macmillan report actually talks about it. You can reduce costs. You reduce costs because you reduce carer costs as well. Because 75 to 90% of the care is actually provided by family. And home-based care is less expensive than hospital care. The UK has a surfeit of documents and policies, and it's not just done by government. It's done by regulatory agencies, it's done by charities, and it is a very coordinated effort. But the state of play just now is that we expect the demand on palliative care to increase because we have a very aging population. As you can see, that the number of people over the age of 65 is just going to increase. COVID has actually put a huge strain on services and also made the delivery of services very difficult because we were unable to provide family visits. And actually that's caused a lot of post-traumatic stress for the carers and the survivors of these patients. And there is a huge inequity. You can't say that there is any consistency across the UK, and that is a matter that needs to be tackled. But there are some ambitions, and the National Framework for 2026 has 6 ambitions where each person is recognized, each person gets a fair chance, there's maximizing of comfort, care is coordinated, and all staff are prepared to help. And we do need the help of communities. We do need volunteers. We do need family, but it can't be a disproportionate burden on families to look after these patients. There are still a lot of barriers to accessing end-of-life care. It seems to be all to do with communication. There have been some studies that have been done, and it looks that even now doctors are very hesitant to actually bring up the topic of dying or terminal illness. And often families feel it's too late. They feel that this coordination with palliative care should happen at the diagnosis level, but it's very difficult because at the time of diagnosis, even doctors are not quite sure how the disease will evolve. But what we probably need to do is to be honest to patients. 1 in 4 patients still have difficulty in accessing, and ethnic minorities and patients from the LGBT communities and people from deprived areas in the UK still have struggled to access care. What happens in the intensive care where Paul and I work? Well, there's curative care up to a point, and then the teams realize that actually either the treatment will not fulfill, are not aligned with the values, the wishes of the patient, might provide some sort of benefit, but that benefit cannot be justified by the burden of treatment. And I know Paul hates the term futility, but we do have to have a consensus decision. And we do, in our multidisciplinary teams, we do discuss it with the referring teams. We do discuss it with everyone in the team. Even if one consultant has any reservations, we usually give it some time for us to see whether we can actually see whether time itself will make it more obvious to us how we should proceed. With our end-of-life care, we do have comfort tools that we use, where it triggers a discussion about organ donation as well. We ensure that a DNA CPR document is done. The end-of-life documentation is standardized across all NHS trusts. It's different from Scotland, Wales, and Northern Ireland and England, but it actually follows the broad principles. We do actually focus a lot on the family. We sometimes have to wait for family to arrive from afar. We sometimes have to wait to give the family privacy. We also have been not that attentive to religious and spiritual needs, but that's becoming a huge focus now, certainly after COVID. And we do try to make memories for these patients because for the families, those that survive do need to have some positive experiences when their family member was dying. We have moved away from actually talking about withholding and withdrawing, and we talk about changing the focus of care, saying that actually continue, that the care doesn't stop, but the treatment may do. We use words like burdens and benefits. Health literacy in the UK, contrary to people's expectations, is only just less than 50%. So sometimes these terms that we use, the jargon that we use, is not easily understood by our patients, their families, and our sort of clients. We do look to see whether there was any advanced care planning done in Scotland. As soon as a patient gets admitted to an acute area, a treatment escalation plan is discussed as well. And we do have the Mental Capacity Act, or the Adults with Incapacity Act, that allows us to act in the best interests of the patients. Our DNA CPR form is really, really prescriptive. It can be signed by a junior doctor, but it has to be countersigned by a senior doctor. We do have to document that we've spoken to a family member about it, or the patient themselves. And there are 3 categories. If the patient has an advanced directive, it's category 3. But most often, if the patient actually lacks capacity and they are in an intensive care unit, it's usually category 1, where we know that CPR is unlikely to be unsuccessful because they're on multiple organ support. With patients who have cancer or chronic heart failure, it might be category 2, where the likely outcome of successful CPR, we might be able to get a return of spontaneous circulation, but would be not of overall benefit to the patient because we might not be able to return them to their previous level of function. What happens in practice is that we do trigger the end-of-life pathway. It's standardized. It has to be filled by a consultant, and we remove all agonizing treatments, and we are moving towards extubating patients. We have end-of-life prescribing, which is again done along with palliative care teams. In the last 10 years, I must say, we have started involving palliative care teams much more, and it's not infrequent for us to have the palliative care consultant and the palliative care nurse specialist in our units speaking to the family. We ensure and facilitate access for loved ones, and as far as possible, even with blood pressures, we try not to move the patient out of ICU because we don't want them to think of this as an abandonment of the patient, that we're not interested in the patient once they are not going to survive. But there are some difficult situations with ECMO, out-of-hospital cardiac arrest, where neurological outcome is difficult to prognosticate, and long-term patients. And COVID imposed a huge sort of challenge for us in the way we manage these patients.
Quickly.
We also provide a lot of support to the staff because we realize that the staff are actually quite beleaguered and inundated with their experiences. There's psychological support provided by occupational health. We have healthcare chaplains. Previously, they were Christian chaplains, but now we have multi-faith chaplains as the community and society in the UK is becoming more diverse, who actually will walk into the unit and walk around the beds and speak to the nurses and speak to families if they wish to. We have a death debrief that we do in our unit 3 times a year. It's called Coffee and Comfort, where the palliative care consultant and ICU consultant and staff are encouraged to drop by, where we discuss the deaths that have happened so that it's not something that we want to hide away from. It's something that we can all discuss. And actually, staff often say that they find some sort of some end-of-life experiences quite distressing. We have now started hosting a remembrance service in our unit to acknowledge the loss. And we also have, most hospitals do have memorials to commemorate. So that death is as big a part of the hospital as preserving life is. And these are just some photographs of our sort of remembrance service. There was a remembrance tree, and we'd had a very, very impressive attendance. This was during the pandemic. So we had to wait for the pandemic to be over, and we did it in November. And again, the money for this did not come from the hospital. The money for this came from a bereavement charity. So the charitable sector in the UK does contribute a lot actually to the care of patients. Thank you.
Thank you, Radha. Sumana, if you're there, maybe we, as per the plan, we could spend the next 7 to 8 minutes to have some responses or questions to the talks by Paul and Radha. So, Sumana, would you like to start? Would you take this?
Yes. So my question is to Paul. Paul, we were talking about mediation and all of that. But so my question is, what do you think is the role of clinical ethicists or clinical ethics committees in supporting families and clinical teams when there are situations like this?
So I think that the provision for clinical ethical committees in the UK is actually required. There are very few of them. I'm not sure there is actually one within Scotland. I think some of the London centres might have them. I think we have to acknowledge that these are difficult decisions. We have to acknowledge as well that when we talk about best interests, those go beyond medical considerations. You aren't just your condition. You are a person within yourself. The person in the bed in front of you isn't just a pancreatitis. They have their own dreams and experiences, and nothing can lose sight, and you can never lose sight of that. I would like to see bigger provision for them. I think that's the easy part of the question. I think the more difficult part of the question is actually who should be on them. Yeah, we need medical expertise on them, because medical best interests, if you're in intensive care, they form a large part of your best interests, but they're not the sole part. And we need to have a way of including lay people and different experts on that as well. And if you're actually going to use your ethics committee, to help smooth the way during these difficult times, to help with decision making, they can't be too medicalized, because if they're too medicalized, then the families, the patients themselves do not feel empowered or protected. They need to be a step back from the hospital. So I think you probably don't need individual hospital committees, but more a sort of regional type service from them as well. And I suppose it's the same when we have research ethics committees. It's not just doctors that are on them. There's lay representatives, there's legal representatives, there's statisticians as well. A clinical ethics committee should be no difference. It should represent everyone, because that's how we do the best for our patients.
Yes, I agree. Thank you. Sanjay?
Yeah, so, let me first remind everyone that we, of course, have a fairly much larger segment at the end of today's webinar to raise questions, issues. So our friends from the UK will still be with us. But since this particular segment is focused on their talks and what happens in the UK and the Archie case, I just, when I actually read a little bit in detail about how the case played out, to me, and as this is probably as someone who comes from a perspective which is South Asian or Indian, the remarkable thing about how it ended was the fact that the British courts and the BART's health system, or the doctors, actually were very firm about acting against what was purportedly the stand and the interest of the parents. So in most parts of the world, the parents would be very clearly decision makers for a kid. Now we know definition of children, kids, etc. differs from. So where does this come from, in the sense? What is your view about acting clearly against the views of the parents?
So I think what we've got to do is look at this in the context of UK law. Okay, so in the UK, there's the 1989 Children Act. And again, that puts the focus very much on best interests. Okay, and the parents, as I said in my talk, under UK law, don't have rights in themselves. For heaven's sake, never actually say that to a parent if you're trying to diffuse the situation. That won't go well. But they don't have rights in themselves. They have certain powers that are gifted to them to allow them to fill their obligation. But whatever they do must be in the best interests of the child. And when you say it like that, I think that's really important, because it actually recognizes that children are people too. Okay, and it gives them some sort of semblance of control and some sort of semblance of individual identity. Now, the threshold in the UK when the court should be involved for medical purposes is one of best interests. And as I alluded to in the talk, that's a really low bar. Okay, that essentially just means that as soon as there's a disagreement, you can go to the court because you're worried about the best interests of the child. Now, from a social point of view, if you were actually worried about abuse or neglect, you actually have to cross a threshold of significant harm, which is a much higher bit. And that recognizes the sort of certain roles of the parents, that people might have different parenting styles. Okay. Probably a case to think about when we're considering this is the King case. Now, I don't know if people can remember that. Again, captured sort of the headlines for a while. This is a young child with, I think it was a neuroblastoma, who was declined proton beam therapy within the UK. As it was deemed not to have any additional benefit over the radiotherapy that was going to be offered. But his parents took him out of hospital to take him to, I believe it was the Czech Republic, for proton beam therapy. Now, what then happened was that the hospital essentially involved social services, and an international arrest warrant was issued for the family to bring the child back. But the minute that got into court, that was chucked out. And one of the things the judge talked about in that case was the reasonableness of what the parents were doing. The parents weren't putting their child at significant harm. They were taking him for a recognised therapy. The reason it wasn't offered in the UK was it was felt that while it was safe, it didn't offer any additional benefits because his tumour was so diffuse that the focused nature of it would not have any additional benefits in preserving function or safety. So the judge there acted on the idea of reasonableness from the parents. And this is actually, I took a couple of wee references in my talk, and you can go back to them and look at it, but this is a big discussion within the UK. The trouble as well with the best interests doctrine is the minute best interests are invoked and the court's invoked, you can only have one outcome. It's got to be the best one, and the best one is what the court says it is. Now, that pays no attention to all that. Actually, there might be shades of grey here. You know, there might be different things. If we think about the Guard case, his family were offered treatment, albeit it was of a dubious nature, from an American physician. Okay. Is it not with a reasonable thing that they would try to exhaust all avenues there? But again, once the court's involved, the courts have to come to a decision, and that, because of the paramountcy principle, will always be in the best interests of the child. So it's really difficult here. And I've got a lot of sympathy for the parents because, as was said in that quote, the parents are not challenging medical wisdom, you know, out of a place of malice. They're challenging it because their obligation is such that they must go above and beyond for their child. I think it's a perfectly natural response.
Right, Paul. Thanks. Radha, you want to just quickly comment on what I said? Because, you know, the difference for us coming from this part of the world is that the parents' wishes were overridden. So that culturally is just something which is jarring. But if you want to make a comment, and then Sumana, maybe we can move on to the next segment.
No, I agree with Paul. It's difficult, but the best interests of the child, certainly in the UK, are protected by social services, by society, by the state, by the courts. I find it quite interesting, you know, that if a child is abused, you actually have to have a huge body of evidence before you can actually remove the child from that abusive household. Whereas the bar is quite low for us to go to court. I don't actually know how many parents actually challenge decisions. The ones my sense is that when they do, and when we go to court, it does make national news. I think it's few, but we may see an increase. But you're right, it's different, but I think it's because the state plays such a huge role in looking after or advocating for children.
Right. Okay. All right, Sumana.
Thank you, Dr. McConnell, and thank you, Radha. We'll now move on to the second segment. I'd like to introduce the first speaker for that. So it's my pleasure to introduce Dr. Dhwani Mehta, who is co-founder and lead health at Vidhi Center for Legal Policy, Delhi. She has worked specifically on research projects on environmental clearances, the National Green Tribunal, organ transplant laws, end-of-life care, and pharmaceutical and medical device regulation. Dhwani read for a doctoral degree at the University of Oxford on a Rhodes Scholarship, and her doctoral thesis explores the idea of an environmental rule of law in India and was cited by the Supreme Court of India. Over to you, Dhwani. Dhwani doesn't have a PowerPoint presentation, and that's great. Please go ahead.
Thank you. Thank you for the kind introduction, and thank you for inviting me to speak at this webinar. Yeah, I'm always intimidated by doctors and their very, very aesthetically presented PPTs. So I know I can never match up to those. So I always decide that I'm just going to speak off the cuff. So actually, it's really interesting for me to be speaking at a webinar like this, because over the last 4 years, after having been involved with the legal and ethical issues related to end-of-life care in India, along with the End-of-Life Care in India task force, I found myself, for the most part, speaking at webinars at hospitals or to professional medical associations, where I explain what the legal position currently is in India. So I'm mostly talking to anxious doctors who are worried about whether what they're doing in the ICU is, legal or not, and trying to reassure them that, the ethical thing is also the legal thing to do. But the kind of talk that I usually deliver is a very factual one, or at least one where I put on a lawyer's hat and try to tell people how I think the law is currently being interpreted. But this webinar is an opportunity for us to, take a step back and think about what the basis of the law is, what are the philosophical underpinnings of the law as far as end-of-life care is concerned in India, and what we can think about, in the future when we try and think of what a legal or regulatory framework for this in India should be. So what I thought I'd do for the brief time that I have to speak today is that I'll give an overview of what the current legal basis for end-of-life care in India is. So again, I think this is a fairly well-informed audience, so maybe I don't need to go into the specifics of what the legal position is and what the current judgment of the Supreme Court in Common Cause says, because I think most doctors will be well versed with that. I can give a brief overview, and of course, I'm very happy to answer any questions later at the end. But I thought I'd speak a little bit about what are the concepts on the basis of which the law has developed in India, where there are gray areas and where there's scope for us as a society, both of lawyers and of medical professionals and patient rights groups and civil society organizations, to think a little more about these issues as we fashion a new legal framework for ourselves. And in that context, of course, it's been very instructive to read the judgment in the Archie Battersbee case, to hear Paul and Radha speak today, because these are the two very different legal cultures that we are talking about as well. Legal, perhaps medical cultures as well. And the manner in which the law has developed in the UK and the sophistication with which judgments are pronounced. I mean, I know that there are problems with those as well, but it's, in India, these conversations are nascent and are just, beginning to take place. And therefore, perhaps there's time for us to pause and think about, how we want something like this to evolve in India as well. So broadly, I'll talk about what, as I said earlier, Common Cause versus Union of India was a landmark 2018 judgment handed down by a 5-judge bench of the Supreme Court of India that finally sort of, authoritatively pronounced that the withholding or withdrawal of life-sustaining treatment is lawful. I mean, there were problems with the way in which it did it because it conflated it with passive euthanasia, and there are issues related to that. But, as far as the crux of the judgment goes, it recognized that this kind of withholding withdrawal was lawful under certain circumstances, and it laid down a complex set of guidelines to govern that. And the second thing is that it recognized that advanced medical directives were legal. Now, what was the legal basis for this? So again, there are several judgments that have been handed. I mean, there are several separate opinions that this 5-judge bench has handed down. So it's a little difficult to glean what the exact ratio of this decision is. But broadly speaking, the bedrock is Article 21 of the Indian Constitution, which is the right to life, and which also guarantees the right to die with dignity, although the court is also very clear that this does not mean that it guarantees the right to extinguish life, which means that the question about assisted suicide or active euthanasia, so to speak, is one that will have to be considered in the future, perhaps either through another judicial challenge or through legislative debate and intervention. In addition to this constitutional rights-based approach which the court has to end-of-life care, there is also a lengthy discussion of the common law right. So again, India is a common law country like the UK, where the law develops not just through statute, but also through case law, so through decisions that are handed down by courts. So there is a very strong recognition of the fact that even prior to the constitutional right to life, there has been a common law right to refuse medical treatment, and any intervention that is provided against such refusal constitutes, an assault or battery in the common law. Now, this is the very broad brush strokes of the decision itself. In addition to this, the court articulates what are the different kinds of values that animate the right to life under Article 21. So of these, the 3 prominent ones are autonomy or self-determination, linked to that, the right to privacy, and then finally, the right to dignity. And all of these are core facets of Article 21, and all the different opinions of the court discuss these different values. Though again, as Paul said, it's very hard to sort of understand or articulate or to distill what the court concretely or tangibly means by dignity. So, we know that this is an important value for the court, and the court recognizes that for most people, refusing a certain kind of death is an important aspect of the right to die with dignity. But how that would apply in a specific factual situation, we don't know, and we won't know until we have a test case like that. What is also important to remember, though, is that there is no real discussion. I mean, again, in the context of the Archie Battersbee case that we are discussing today, because the court is so fixated on establishing the existence of the right to refuse medical treatment and have a certain kind of dignified death, it doesn't really get into an in-depth discussion on how this decision should be made, apart from the procedural guidelines. So there are very lengthy procedural guidelines that the court lays down who should take this decision, how it should be ratified, what are the different kinds of safeguards that should be in place. And, of course, underlying all of this is a real anxiety about this process being misused, which speaks to a kind of deficit of trust, both in the medical system as well as, within society in general. But what the court doesn't really get into is what are the substantive principles on which decisions will be made. So there are references to best interests, etc. But what best interests will specifically mean, how it operates versus substituted decision making, how it operates versus supported decision making, how it interacts with guardianship. These are not questions that the court has explored. And again, so this is, there's going to be scope to perhaps discuss all of this in much more detail when cases like this begin coming to court and courts begin having to deal with difficult questions like this. So we haven't seen that, and we can't say what the court will do. And there hasn't really been a case like the Archie Battersbee case in the Indian context. But should something like this arise, we don't really have a very strong jurisprudence to rely on at the moment. And in that context, I also wanted to briefly speak about what the law says about parental responsibility in the Indian context. So again, a point that Dr. Nagral brought up, the idea in India that, we could override what parents' wishes are for their children and have legal recognition of the fact that children themselves are rights bearers, and there is an objective standard that could be applied to what should or should not happen to them in the context of healthcare decision making might be alien to us. But actually, as far as the law goes in India, we also have the concept of guardianship. So unlike the UK, where there is parental responsibility, and I owe all of this information actually to a former colleague of mine who's done a little bit of research on this and explained this to me before the webinar. Unlike the UK, where we have parental where there is parental responsibility, which Paul was talking about, in India, both fathers and mothers are considered natural guardians of their children, and the court is also considered a guardian. So we have something called parens patriae jurisdiction, where the court is seen as being the ultimate guardian of, this doesn't necessarily have to be minors. It could also apply to an adult who became, who was unable to exercise decision-making capacity at a point in the future. And there are a lot of Indian cases around, some Indian cases around guardianship in this context and how the court makes decisions about best interests. So even in India, there is an idea that the court will act in the best interests of the child or whoever the ward of the court is. So there is perhaps an objective standard to be uncovered, but we're not entirely sure how the court would go about doing that. There have been law commission reports where it's been stated that best interests should obviously encompass not just medical considerations, but social, emotional, welfare and other considerations related to the person in question. But this hasn't been codified yet in India. So I think just to wrap up my talk, and again, I'm very happy to go into any of these details in any of these questions in more detail later, is that in thinking about what a forward-looking legislative framework for India could look like. And the reason I'm saying this is because the judgment in India is supposed to operate, or the guidelines that the court has laid down for end-of-life care are supposed to operate only until legislation is passed in this regard, is that there is scope for the law to be more sensitive to how decisions like these are made. And, maybe there's a way for us to think about how the law should incorporate good medical practices within its ambit in a way that allows, in a way that is not unduly interventionist. So, actually, there's a line in the Archie Battersbee judgment that really struck me, which was, that the law and good medical practice will rarely, if ever, diverge. And this is ideally what we want the law in India to reflect as well. We want it to reflect good medical practice. At the same time, we want the law to be cognizant of the fact that perhaps the kind of trust deficit that exists in Indian society vis-a-vis doctors and patients is something that the law needs to take account of. We also have to think about what the role of the law really is, right? In all of these scenarios, I think, as Paul said, it's ultimately, yes, the court is going to look at the array of medical opinion, perhaps for the most part, again, as the judge in Archie Battersbee's case said, we will respect or defer to that medical opinion because it recognizes that the law's job is to perhaps provide sanction or authority to that kind of good medical practice. But we have to think about why is it that we go to courts in this scenario, right? Because there's an intractable dispute that has arisen between doctors and patients. We know perhaps that courts don't necessarily have more tools than the medical or clinical ethical team that is already taking these decisions. So perhaps what the court is really doing in these scenarios, or what the law is really doing, is maybe acting as a kind, I don't know, like a kind of repository of public trust. It's the institution that people go to, or should be going to, because they feel that it is the one that they can trust to make a fair and impartial decision. But I think we have to acknowledge that there are limitations to what a court can do in this context as well. So to anyone who's interested, there is, we've in collaboration with the End of Life Care in India Task Force, my colleagues at the Vidhi Center for Legal Policy, have drafted a model bill around end of life care, and that's up on our website for anyone to read. It has some ideas on the kinds of safeguards that the law can have in place, but I'd be very happy to hear comments and questions and discuss some of these ideas in more detail, either at this webinar or later. So I'll stop for now and look forward to the discussion that follows.
Thank you. Thank you, Dhwani. We'll now move on to our next speaker. So I'd like to introduce Dr. Naveen Salins, who is Professor and Head Department of Palliative Medicine and Supportive Care, Kasturba Medical College, Manipal. Dr. Salins pursued his 3 years of specialist fellowship training in palliative medicine and thereafter worked as a consultant in South Australia. In 2020, he was awarded the Fellowship of the Royal College of Physicians by the Royal College of Physicians, London and Glasgow. He completed his PhD in palliative care from the Lancaster University, UK in 2021. He's also the Honorary Professor of Medicine at Cardiff University, UK. He's the Secretary General of the Academy of Palliative Medicine, a national body that aims to enhance specialist and generalist palliative care education in India. He was the head of the department, accredited as the International Reference Center for End-of-Life Care by the International Collaborative for Best Care for the Dying Person, University of Liverpool, UK. Over to you, Dr. Salins. I'll stop share.
Thank you so much for the very generous introduction. Is my slides visible?
Yes, Dr. Salins.
I've been given a very interesting talk, End of Life Care in India, Black, White or Gray. And I was just contemplating as how to make this presentation as interesting as possible in 8 minutes of time. So this is a quote that I have read, and life is seldom black and white. It's a million shades of gray. We always want to be black or white. I would start from what Paul said, that courts in UK want it to be white or black. But it's never white or black, isn't it? It's always shades of gray. And why do we want something to be black or white? Because we're very comfortable with it and we want it to be very certain. But end of life care is a domain where there are more uncertainties than certainties. And the black and white is seldom it's seldom black and white. And rather gave a good construct of end of life care in UK, and Dhwani gave a good legal construct or legal perspective of end of life care in India. I would come in here as a clinician talking about the end of life care in India, and to look at the shades of gray, the opportunities and possibilities. And more than the shades of gray, I would also talk about the polychromatic palette, the various colors, the context, and the diversity, and how it might have an influence on end of life care in India, and how it all relates to the theme of this meeting, that is trust, dignity, and autonomy. So I would start with this one screenshot. I'm sure many of you won't be able to read, it is in Kannada, but this screenshot is 2 days old, on 9th of Jan. This is written by an IMA president, and who is a very famous psychiatrist. And he said, he has written to the public, and is read that the title of this newspaper article reads that if you have patients admitted in the ICUs and connected to the ventilator, know about palliative care. And that's the title of the article. And he narrates his experience of his mother in the ICU and how his interactions with the team of palliative care experts and has changed the way his mother was managed. And this was written to the general public. And he has come with a very polychromatic palette of his own. And what underpinned his decision of palliative care engagement, and how he felt that his inability, or he felt that his mother was unable to communicate, his mother was unable to participate in decision-making process, and her expressed wishes was always that he wanted, the mother always said to him that if I am ever in that situation, do not put me on a ventilator, or I do not want a prolonged stay in the ICU. And here she is now in the ICU, intubated for whatever medical reason it is. And he wanted to uphold those expressed wishes. And he strongly perceived that his mother is suffering. He had a sister who is in UK, and she was en route to India to see the mother. But he strongly perceived that his mother is suffering, and all the tubes and the lines that was there, which was causing the suffering. And the word that he used was the feelings that his mother is imprisoned in ICU, and his son, it's his duty to free her. Now, this is his polychromatic palette, his shades of gray. So if you take each patient and their families and the various providers, they come with various perspectives. And these perspectives are very important while we provide end-of-life care. So that's why I would not want to be a reductionist to say it is black or white. It can never be black or white, because it has so many uncertainties, so many nuances as we take it forward. And this, we experience it richly as clinicians interacting with our patients and their families and other practitioners on a day-to-day basis. So one of the nuances that what we have when we bring in the challenges as a clinician while providing end-of-life care is the trust. And the trust and how it is linked or aligned with the truth-telling. There was a big study that was conducted in Tata Memorial way back in 2016 to 2018, where we looked at disclosure of diagnosis and prognosis. Because there was a very strong notion that patients in India do not want to know about their diagnosis and prognosis. And now there are 2 studies from India. I've provided them as references, where patients prefer full disclosure of their diagnosis and prognosis. But families do not want their patients to know about the diagnosis and prognosis. Now, this puts them in a very unique position, where they are less informed. So they lose that autonomy to participate in the decision making. Now, both of them had their own reason why patients wanted to know, because they wanted to plan for their future. Why families didn't want the patients to know? They thought that they would be upset or it would cause a lot of emotional distress. And physicians in another study agreed that there should be full disclosure to the patients, but they often colluded and did things differently. So this non-disclosure, this non-communication or very poor communication often led to mistrust. And this mistrust that we see day in and day out while we are providing end-of-life care in a critical care setting. And we want our healthcare system, the healthcare providers, to be trustworthy. So what makes them trustworthy, or the trustworthiness in end-of-life care, is something that we should very strongly reflect upon as we are providing. Because, this trust and trustworthiness again comes in with lots of shades of gray. The second construct that what we often talk, and if you read in any end-of-life care literature, they talk about death with dignity, But again, I'm reading a lot of papers now, which has a very contrary view to this construct of end-of-life care, that we always say that all patients who are dying should have a dignity. But if you look, the Latin, the original meaning of the word dignitas means worthiness. What makes one death the worthy? I was reading a very interesting paper which was published in British Medical Journal, where probably Jesus thought crucifixion was worthy death, whereas another person who was crucified thought probably it was a very indignified or worthless death. So it's a very, very personal construct. So now the things are moving away from the construct of death with dignity to a construct of what is called as death without indignity, which is probably much more less abstract and more achievable. And we focus on factors that mitigate indignity. So what is indignity? So indignity is something that is probably more easily explainable than the word dignity. And there are qualitative studies that looked at indignity at end-of-life care. And it predominantly focused on human suffering, lack of autonomy and control. And there are a couple of Indian qualitative studies which looked at indignities, which focused on significant physical discomfort, poor psychosocial experience, emotional distress, lack of communication, awareness, lack of control, lack of preparedness, families getting exhausted, and this negative coping. So probably we need to change our construct here while we talk about dignity and death. Now, another important thing that we looked at is control and autonomy, and I very deliberately use the word abdication. Abdication is used by royal families where they give away their crown and they abdicate. But here, people are the kings or a person is the king of his own life, isn't it? And would have the full control of autonomy. But often in a very critical illness setting, this autonomy is abdicated and the others make decision. It could be healthcare providers or it could be the families. And this is something that what we see very commonly in Indian setting, And a lot of this abdication happens purely because of the attitudes of the healthcare providers, their lack of knowledge on end-of-life care, the ability to provide the skills to provide, the imbibed attitudes from their seniors, the misconceptions which Dhwani touched upon in her previous talk, the way information is shared or communicated, the strong paternalistic attitude, there is agree or abandon, where they feel that they have to agree to their line of management or they're very happy to abandon them. A lot of these factors also are at play when we're providing end-of-life care in an Indian setting. And another important thing which I talked about, the polychromatic palette or the colors, is a contextuality that colors the phenomenon of end of life. And there was a good systematic review that looked at various socioeconomic factors, like how we determine place of care. If you look at a lot of Western literature, they say that home is the best place of care. But is it best in the Indian setting? There are many homes that do not have the basic infrastructure to provide that care. There is also a concept of disenfranchised grief, where a lot of grieving is not allowed by the society, because there is no place to grieve here. And how God and religion is a major source of strength, which is not explored here, where rituals and traditions at end of life is not explored here, where the primary caregiving roles of the family is not explored here. So contextuality of providing end of life care in India is very different than how we talk about an end of life care in a Western world or a country like UK. So it cannot be very readily extrapolated. So I strongly believe in working on this contextualization. And this is some of the work that we are doing right now, both where I'm directly involved or I'm partly involved. So we have done some work looking at scoping review on ICU, because a lot of my work is revolves around ICU palliative care and end-of-life care in low-middle income country, which is completed and published. And we have done 2 other work looking at ICU end-of-life care integration and views of ICU providers on end-of-life care and ICU, which is a pre-publication phase. We're doing other work looking at an integrated care plan for the dying and how it might enhance the quality of life and end-of-life care. We're doing a translation validation work on international care of the dying evaluation in India. We're auditing our ICU palliative care referrals. We are auditing the discharges against medical advice from the ICU. I'm highlighting this work because we need to develop this evidence from India and contextualize the end-of-life care in India. This contextualization can be a very strong research work. So in summary, I strongly believe contextualization is the key when we speak about end-of-life care. We need to know the color palette of end-of-life care in India. Truth-telling is important. However, we need a very specified approach for our setting, our population, with a good training and communication skill. We need to recognize indignities. And what are the indignities that are very specific for our context, and what strategies we have to address it, and to see how do we empower, how do we give back control to our patients and families, and how do they become the important stakeholder in the decision-making process. And with this, I stop my presentation, and I'll be happy to take any questions. Thank you very much.
Thank you, Dr. Salins. We will take questions at the end. So I'll now call upon our next speaker, who is Dr. R.K. Mani. He's been in the field for so long that Dr. Mani, you're going to get the shortest introduction, which is, here is Dr. R.K. Mani, Director Clinical Services, Pulmonology and Critical Care, Yashoda Super Speciality Hospital, Ghaziabad, in Kaushambi, Ghaziabad in UP. He's had more than 40 years of experience in the field of medicine, pulmonology and critical care. Over to you, Dr. Mani. If you'd like to share screen, please. I'll stop share. Dr. Mani? I see you there. While I think we'll try to get him, we'll move on to the next speaker while I send him a message, and that would be Dr. Vidya Vishwanath. So let me just introduce her. Dr. Vidya Vishwanath is a palliative care physician working at Homi Baba Cancer Hospital and Research Center, a unit of Tata Memorial Center at Visakhapatnam in Andhra Pradesh. She trained and transitioned from transfusion medicine to palliative medicine after observing the
Oh, Sumana, I'm very much connected. Sorry, I didn't, I had muted myself. Yeah. So I'll just carry on. Okay. Can you,
yeah, Vidya, is that okay with you?
Can you stop this?
Yeah,
I'll just carry on.
Okay.
Because I'm
whatever
connected.
works for Dr. Mani and you is fine with me.
Okay, this time beauty is giving way to, what should I say? to experience.
The beast.
No. Go ahead, Dr. Mani. If you could please share screen. Thank you, Vidya.
No worries.
So
Yes.
the topic given to me is ground realities in India, EOL case studies. Okay.
Dr. Mani, have you shared screen? I mean, your PPT.
Yes, I have.
Oh, is it?
I've shared screen. Is it not showing up?
Mahendra?
I have shared screen. Wait a minute.
Please share again.
Wait a minute. Where is share is not coming up. Share is not coming up for me.
Maybe it's on top of your screen or right on top or below.
Why is the share not coming up?
Do you want me to
Strange.
share?
Yeah, you share, please.
Shall I do that? Okay.
Yeah.
Just give me a minute. We can start talking if you want.
Yeah. I see the ground realities in India. Now that is the topic, and the EOLC case studies. There have not been many case laws in India, okay, except for Aruna Schonbach. But I'm going to talk about the ground reality, though that's an extreme case. So I'll talk about my own cases spread over 2 decades. I'll give 3 case studies. Now, the issue is Naveen had talked about the spectrum of colors. Okay, the spectrum of colors.
Can you see the?
Yes.
Yes. Okay, go. Just tell me when to change. Yeah.
Yes, the polychromatic palette that he was talking about. So that is, come on, move.
Yeah, I do that. Yeah.
Right. Now, this is an editorial by Randall Curtis from Seattle, who's one of the pioneers of palliative intensive care and the intersection thereof in end-of-life care. So you see, there's an intersection of multiple things: the national culture, the institutional culture, the institutional policy, and the spectrum of values and the beliefs that clinicians hold, and similar values and beliefs and religions and faiths that patients and families hold. Then whether there is a national policy, legal policy or not. So all these intersect in multiple ways to create that polychromatic palette of decision making for an individual patient. Next. So you can see there are multiple barriers to ethical decision making in India. While ethical decision making, you will see withdrawal, withholding, and other difficult decisions that have to be navigated seem very complex, seem very difficult, but on the ground they are being frequently made. In Europe and the US now, 70 to 90% of deaths in the ICU are reported to be through an end-of-life decision, either a simple one or a complex one, but majority are having a cogitation over ethical issues, and these decisions are being made. They are not getting full support, in the majority. Now, while this sort of decision making becoming more systematic, more institutionalized, more settled in the West, this is not so well developed, well evolved. In fact, it's very much arrested development in the last 20 years that I've been involved in this area. Of course, there are multiple reasons, and many of the reasons are common to several across cultures, as enunciated in the Lancet Commission, which was published recently. on the value of death. Now, this cultural awareness and taboos of death denial, unrealistic expectations from science and intensive care, and the culture of fighting till the end, this is accentuated in India, and it is accentuated further by the huge economic divide and inequities. So a lot of the people are having bad deaths because they're denied access to intensive care, and many are in a privileged position, but they have, again, poor death and dying because of the lack of discussions around death and the unrealistic expectations. And this has also widened the gulf between patients and the caregivers. Of course, there are legal inadequacies in spite of some settled issues like the common cause, constitutionally validating withdrawal and withholding. Still, there are inadequacies in practice on the ground. So this is not translated on the ground into facilitating end-of-life care decision-making. Lack of ethics training, and integration in practice right from the graduate to advanced levels of training, and lack of focus in healthcare policies on ethics of, the evolved biomedical ethics. They are on very primitive level of biomedical ethics. And the regulatory authorities as well, similarly. Institutional policies are self-serving because 80% of healthcare delivery is from the private sector, and the priorities are different from focusing on biomedical ethics in practice. Physician mindsets, habits, and unresolved fears, because they are not being trained or oriented this way, their mindsets are again molded into the curative, success failure sort of mindset, and then habituated not to address these sensitive issues or to communicate very openly. And unresolved fears about the legality of what they think ethical practice would bring. Now, I'll talk about a case. One of my earliest cases, maybe 15, 16 years ago. This was a 40-year male with valvular heart surgery and then post-operatively infection, and then sepsis, and this went on into a multi-organ failure. 3 weeks later, on a mechanical ventilator, vasopressor, intra-aortic balloon pump support, CRRT, and comatose because of septic encephalopathy. Now, this was the scenario. And next, the situation is the family was anguished. They didn't know what was happening. They were every day called and told that there is no hope, and there's nothing is going on in the positive direction. He's only deteriorating, and really they can do nothing. If they would express their helplessness in modifying the trajectory of the disease, and they had come to terms with this, and they had accepted the poor outlook. Now they hit a rock of financial crisis, and this is another shade of color in India. All right, there's a lot of people, 40% of families may find themselves financially in difficulty, and a lot of them have catastrophic expenditure, out-of-pocket expenditure, with nothing to fall back upon. So they were unable to bear costs. And then what did the caregivers tell them? Caregivers said, it's illegal to remove supports. In fact, the family asked, can we not remove all this if you are heading nowhere? Left against medical advice is what the doctors recommended. This is another name for abandonment, right? Another name for washing one's hands off, like Pontius Pilate, right? So this is not addressing any ethical issues, not getting into any sort of sensitive discussion or essential discussion, as the Lancet Commission would say. It's not just breaking bad news. It is not discussing essential information, essential goals of care and what to do now. The family was confused in a distressful dilemma, so they got embroiled in a conflict with the treating team and the hospital management. A second opinion was sought. It was sought from me because I was working on end-of-life care. So they called me not as a pulmonologist, but somebody as the homegrown ethicist, right? So we don't have an ethics department. Most of our hospitals don't have a palliative care department even in this country. Now, this is an emerging specialty, but with poor penetration so far. How was the conflict resolved? It seemed common sense and simple. I did not have any guideline other than the one we wrote under my chairmanship by the ISCCM, Indian Society of Critical Care Medicine, the ethical position statement. So I was speaking from those deliberations we had between the members of the commission. So the family, having been told it was illegal to remove supports, we move on to the next slide. We only had to, we go back to the previous one. I'll explain. So all we had to do was to have an agreement between the family and the caregivers. And the decision was made not to escalate and to de-escalate. There were many things to de-escalate. We removed the IABP, we removed the CRRT. All right, the vasopressors were not escalated. And then so happened that in a couple of hours, the patient passed away peacefully without any visible pain or discomfort. And the family went home in gratitude, to be honest. So that was the good outcome, and the conflict and and difficulties with the management resolved, and they really thought that the team was very caring, and so we restored some degree of trust between the caregivers and the family. The second case was a little more complex decision. It was a few years later. Again, we did not have any legal guidance in the country. But whether we have legal guidance or not, there are stark realities on the ground. I will tell you how. This is a 75 years male with a retired bureaucrat, very well educated and articulate. He was transferred from another hospital for a weaning failure. It had prostatic cancer, metastatic, and then refractory to treatment after a long struggle. So he was on a tracheostomy. He was communicative through writing and through, hoarse voice. He could express. And he was very articulate. He also had hypertrophic cardiomyopathy, obstructive cardiomyopathy, and therefore chronic heart failure. And the treatment options were not great for that. Patient consistently beseeched me that please remove the ventilator. I really don't want any sort of intervention. My wife died 2 years ago. My family is small. I have a daughter and a grandson and a son-in-law. Now my only goal in life is to be able to play with my grandson. If that you can restore, then it's okay. If you can't, then it's not worth it. Next, even the daughter and the son-in-law were very clear that the father had expressed very clearly he didn't want to continue on life support. If he can remove and he can continue with life, that is okay. But this is not the light he wants to be in. So, but we had all these doubts. Although, I wanted to help him. I wanted to listen to him. I wanted to see. Anyway, I had to respect autonomy. That's clear. Whether or not there's a law, you have to respect autonomy. It is simple rule for doctors and for humanity. But we were wary of a WLST decision, withdrawal life support, how the court would view it, and should this case go up. The prognosis, again, is never so certain. They're not black or white, as Naveen had said. Even the prognosis is not black or white. Yet we have to negotiate through it. So we needed some time for clarity to come, and therefore we bought some time. And after 3 weeks, we were in the same position. And he said, "Doctor, you promised me you will listen to me, that you will respect what I'm saying. Doctor, I can sign anything, but please help me. I know you will." He emotionally also made a big appeal. And I said, "I cannot run away. I cannot do Pontius Pilate." All right. abandon, wash my hands off, look the other way, hide behind science and rules and regulations. So what we did was we took a decision that, patient can refuse anyway. I can directly take refusal. I don't even have to take a substituted judgment. Here it is very clearly, I can directly record the patient's refusal for continued LST. So I'll make one final attempt at weaning. And if it doesn't succeed, then, well, I will not put him back. So that's how we resolved it. So he passed away, grateful to me. His eyes showed gratitude. His family showed gratitude. And they said that we have not seen a caring team like this one. Next slide. So this is what happened. So next slide. So there was a mitigation of moral distress with me as well and with my team members as well. Right. Let me add that. There's a physician point of view as well. You do feel good when you take a right decision. So the third case is more recent. And this was after the Aruna Schonborg and all those cases. And when we had a more legal validity of a withdrawal withholding decision. But even this is quite difficult on the ground. This is a holy man in Vrindavan who said to be 102 years old. In India, many holy men don't remember their birthdays. They come from some hoary past, and then there was a long invalidism due to interstitial pulmonary fibrosis. And he was on home oxygen for 7 years, he was dependent totally. And he had gotten worse over the last few months. He was refractory to standard therapies for exacerbation of ILD next. So he didn't have a family, because he was a renunciate. And there was a large following, many doctors of good standing were there as followers. So they were the significant other, they were the judge, decision makers from his side. And their consensus was that they cannot afford to lose him, right? And therefore he should be given whatever is the best. So we communicated with them. We said that this is taking us nowhere, and really he will not do well on any sort of intervention. But on their insistence, we took him into the hospital, and NIV didn't help. And upon their insistence, we had to ventilate him, much against our conscience. Next slide. However, we can negotiate, right? I'm with some very frank and persuasive talking. And so there was a time-limited trial arrived upon. They agreed that after 48 hours, if it didn't help, then we can opt for a withdrawal decision. So you see, that's why withdrawal withholding have to be on equal footing. Otherwise, you can't give a time-limited trial. You had either or thing. So after 2 days, they themselves came back, verted and said, look, this is going nowhere. No, we must have him in the ashram. He must die only in the ashram. All right, we took him back to the ashram, extubated him there with anticipatory sedation and analgesia and everything. Next slide, please. Then we had this kind of death with proper ritual according to the shastras that were befitting a religious personage. So what is written in the shastras that such personages must be buried in the lotus posture. So this could quickly be accomplished before the rigor mortis set in, and he could be given the sort of send-off, that is said to be dignified. Naveen mentioned about the meaningfulness and worthiness. Now, worthiness is also meaningfulness. If you can get meaning out of your death, and that's why death rituals are important. And that is why discussion of what the meaning for the person would be like is very important. And so we could give him this kind of send-off, right? It could not have happened in the ICU, right? Next slide. So, I wanted to highlight the problems on the ground in India. And majority of the time, these decisions are not being taken in the Indian ICUs, even today, I dare say, except in a few ICUs, like Naveen's and mine and many others, but not enough, right? Not the usual. The norm is to send lama, which is a very pathetic thing to do, very heartless thing to do, and running away from the reality of ethical decision-making and the complexity. So I must say, we have a lot of ground to cover in the evolution of foregoing of life support decisions and ethical decision-making and appropriate care of the dying. So I would like to conclude that in India, Naveen is already on the job. We need an intersection of research, education, and training in ethics. And then the palliative care integration in the ICU has been more complete and more widespread. There needs to be further clarity in law and professional guidelines. Of course, we do have professional guidelines from the Indian Society of Critical Care Medicine, Indian Association of Palliative Care, and Indian Association of Pediatrics, and we have from FICCI as well. So, however, I think that penetration again is not good enough. From ICMR as well, Indian Council of Medical Research. So we do have guidelines, but they've not been disseminated enough. Okay, they're not been integrated by the bedside, which is the real outcome, test of the good outcome. So culture of caring in the ICU must increase. All right, we owe a humane care to the patient. We don't need just a technologically adequate care. So the technological fuss must give way to the centrality of the human being and the care of the human being. So the competencies and communication and ethical decision making has to be a part of the training and development of the intensivist and of course of every physician. We need to intensify our advocacy. We need to improve our mentoring of the succeeding generation. Thank you. With that, I end my talk. Sumana, you are muted like me.
Sorry about that. Dr. Vidya Vishwanath, you can start sharing while I'll just read out the rest of your bio. Dr. Vidya Vishwanath trained and transitioned from transfusion medicine to palliative medicine after observing the impact of chronic disease on patients and their families. She's an honorary tutor in palliative medicine at the School of Medicine, Cardiff University, and is a resource person for national training programs in palliative medicine. Her areas of interest include quality improvement, spirituality in healthcare, integrated palliative care, and qualitative research. She'll be speaking to us on integrating palliative care teams into pathways of care. Over to Dr. Vidya Vishwanath.
Thank you so much for having me here today. It indeed is a privilege. So now let's take a step back. We spoke about end-of-life care. We heard about end-of-life care all along. So my topic today is how do we integrate palliative care pathways? And why is that important? That's because end-of-life care cannot start at end of life. We need time with patients, families to deal with how long we have to live when we are suffering from a chronic illness. So as a broad overview, I'll just touch upon the evolution, the evidence, and a little bit about my experience and the emotion involved. Because finally, that is where it all started. It was emotion that brought palliative care to the world. Dame Cicely Saunders, St. Christopher's Hospice, was born out of it, and then Dr. Balfour-Mount. And most of the evidence that I will be sharing in the presentation today is thanks to Dr. Huey and Bruera. And it was a landmark paper by Dr. Temel in 2010, which actually really showed the world the value of early palliative care. So the importance of integration is something we all understand from a person point of view. We understand that for the person, a holistic care is mandatory in all domains of care. But there is so much of difference between what is perceived and what is reality. And that is a huge chasm which we need to bridge. And bridging that chasm is what integration means to palliative care, because palliative care is an interprofessional branch of medicine. And when we talk of integration, it is not just horizontal integration along the trajectory of care, but for integrated palliative care to succeed, you need to have vertical integration, which means we need to bring together administrative, organizational, clinical, and services. And more importantly, we need to have all the management and policymakers at all levels involved. And this should reflect in our national and international campaigns. And that is why most of the taxonomy that we will discuss in the conceptual models will be based on the levels of care, the timeframes of intervention, the focus of intervention. So coming to the evidence of what the conceptual models are, the first model is what most of us are familiar with, which is the time-based model. So in the past, palliative care always started at the end of curative care. We do not have treatment for you, go to palliative care. But now we have started integrating palliative care way early. And way early, as in there are times when there is intense palliative care at the beginning of the illness, it then plateaus and then continues along the trajectory. We have even moved forward now because today we have disease-based, disease-modifying therapies, which are personalized, which are precision-based medicine, and it almost continues right till the patient lives. So palliative care has to weave in through the entire trajectory for the patient because it's need-based. And when we talk of need-based, we have models which are based on complexity of needs. And so the palliative care physician and the primary care physician, both of them work this together based on the needs of the patient. We also have therapy, we also have care which is specifically for certain diseases like the hemato-oncology models that we have. Now, where do we provide all this care? When we say that we have to provide care based on all of this, where do we provide it? So generalist palliative care has to touch all levels. So every primary care physician needs to be trained in the basics of palliative care so that generalist palliative care is provided at all levels. And then as the expertise increases in palliative care and as the needs of the patient increase, we have secondary centers and tertiary units of excellence where we have academic courses and research going on in palliative care. So when we talk about palliative care provision in all these places, how do we provide it? We provide it on an outpatient basis, as an inpatient service, and at the community-based level. So when we say outpatient service, we have these clinics which are co-located or embedded within the primary units. We have inpatient models where even if you do not have beds, you can still have a consultative model, and community-based palliative care, which will actually penetrate and reach patients' homes. Now, we understand the most important thing is the integrated model, which was Huey Bruera's model, where all of this is what we want. But how do we collate it all together? Because how much ever we wanted, one physician cannot give all this care to one person. And at the same time, we cannot fragment care by sending one patient to 10 different specialists. So that is where the bond between the palliative care unit and the primary care unit is so important, because this is what integrates care together. But what is even more important is that this system has to be uniform. You cannot have a hospital with one set of doctors practicing one model and the others practicing something else. So that is where vertical integration is important, because we need to embed this in the system where all doctors follow the integrated model if it works best for us. Now, most of my guidelines are from cancer so far, because we have a lot of referral criteria and guidelines here, because cancer has been the catalyst for palliative care. But when we talk about non-cancer, we do have models for advanced kidney disease, neuropalliative care, which runs on a framework, which is our scope of discussion today. We do have models and we do have studies for the elderly, for COPD, and for chronic heart failure, among others. So what is the essence is, irrespective of the disease, what is needed is timely palliative care. When the patient needs it the most, we should not be deserting or abandoning him. And to do that, you need multidisciplinary teams where you have diverse members, but but the decision-making is shared, the responsibility is shared. And integration, so far I spoke about, was in service, but integration is also needed in education, in training and research. And we do have, as in the Indian scenario, we have a lot of project ECHO, we have the EPEC, the LNEC, EQUIP, the UICC, the ASCO, ESMO, all of these bodies globally do support us in education and training. We have our own MD programs, we have our own NGOs, we have our National Cancer Grid, we have education and training opportunities in UK, Australia, and Singapore. But the bottom line, as Dr. Naveen Salin's study says, is that we have an urgent need to standardize these services. That is where we stand today. Talking a bit about my own experience, we at Homi Bhabha Cancer Hospital are an ESMO accredited center for integrated oncology and palliative care. We have our OPD, our IPD, and we also have an integrated hospital-based continuity of care where we reach out to patients through telephonic services and through our home care program, which is supported by the CIPLA Foundation. And just for one example, this is a screenshot of our joint clinic, which we have every day in the hospital. And this clinic, actually, where all specialties, we sit down together and we have the clinical discussion. And when we click on palliative as our treatment plan, which means that the intent of treatment for this patient is palliative, automatically the selected discipline of palliative medicine pops up on screen. So it is embedded into our system, into our EMR. But this is my last slide. And I think the essence for good integrated palliative care services is still emotion, because team building, having the generosity of spirit, and having empathy, not just for your fellow colleagues, to your patients, and most importantly, empathy and action, which go together. And that is where compassion comes in. And so palliative care, integrated palliative care is everything about, experience, evidence, and emotion. And like they say, a dot can be just a full stop. But once we start connecting it, it becomes a work of art. And that is where I hope we are going when we talk about integrated palliative care. Thank you so much for this opportunity.
Thank you, Dr. Vidya. That last column is actually so beautiful and encapsulates everything that you were speaking about. Thank you. I'd now call upon our last speaker. Vidya, if you could just stop sharing screen. Yeah, thank you. Our last speaker for the day. Yeah, sorry. Am I on mute? Yes, our last speaker for the day is Dr. Zubair Mohammed. Dr. Zubair completed his MBBS training from Government Medical College, Thrissur, India. His subsequent anesthetic and intensive care training was from Allahabad and then the UK. After completing his liver transplant fellowship at King's College Hospital, UK, he worked as a consultant in the cardiac ICU at Middlesbrough, UK, and subsequently at the Amrita Institute of Medical Sciences, Kochi, as associate professor in anesthesia and critical care, where he was in charge of the surgical and transplant ICU. He joined as consultant in adult critical care at King Faisal Specialist Hospital and Research Center, Medina, Saudi Arabia, in April 2022. He will speak to us about end-of-life care in Saudi Arabia and perspectives on organ donation. Over to you, Dr. Zubair.
Thank you, Dr. Sumna. It's a pleasure, and many thanks for inviting me for the speak. I would like to share my screen. Just let me know if you can. Can you see my screen?
Yes, we can. Yes, we can.
Oh, brilliant. Yes, thank you. So it's an honor to share the platform with the likes of Dr. R.K. Mani and Dr. Salins. My topic is slightly different in the sense that it's sort of an amalgamation of what's many of my previous speakers has spoken about. So they spoke about the perspectives in the UK and India, and I, having been me being someone who recently joined King Faisal Hospital in Saudi Arabia and been working here for about 9 months, I'll give a brief overview of how the system is in Saudi Arabia and what is envisaged by the establishment here. So, like with any process, you would for it to be working, you need a robust legislation and infrastructure support.
Dr.
Good
Zubair,
pathways.
sorry to interrupt. Could you just put it on slideshow?
Is it on? Not on slideshow.
No.
Sorry. Can you see my video?
Yes, I can.
Okay.
I think it would carry on with that.
Yeah.
Okay, yeah.
And now it's
See you.
fine.
I thought I had put on slideshow.
It's fine now, Dr. Zubair.
Okay. Fine. Okay. Right. So these are the following headings under which we'll present what the end-of-life care scenario is in the Kingdom of Saudi Arabia. Okay. So first, let's talk about legislation. Now, the law in the country is slightly different in the sense that when there is an issue, the law is being formulated based on the Holy Book and the practice of the Prophet Muhammad. Now, if they do not have any rulings that could be derived for that particular issue from these two sources, that's when the consensus of the Islamic scholars come into play. And if they do not get any adequate information from the above three, they get into analogical reasoning. And it's only when the next, all these four sources are exhausted, would they then get into exploring other sources of law in order to formulate the plans for the country. Now, what happens is that the Islamic fatwa of do not resuscitate was issued by the country in 1998, so quite some time ago. And what it formulated was that a DNR decision should be made by at least 3 physicians, and 2 of them should be of consultant designation. And it also stated that when there is a conflict of interest regarding the DNR decision, that should be then referred to the chairperson or the medical director. What is interesting is that unlike many other parts of the world, the law here states that the DNR is a purely physician decision, and the patients or the family members do not get a say in the decision-making process, because the law here sees it that they're unqualified to make such medical decisions. However, if the family does not agree with the decision, they should be offered a chance to take their relative to a different hospital that they desire, but the DNR order will still be valid up to the first 24 hours that they go into the new hospital. In reality, though, when there is a difference of opinion, as you would all expect, we do continue to treat and continue the counseling process till both parties come to a consensus. The law also states that as far as pediatric age group is concerned, the families could decide on behalf of the children, as they may not be able to decide what is the best for them at that point in time. The equivalence of guilt competency is also addressed and in the law, and it states that the child would be able to make decisions that is appropriate for the child's understanding. Am I going the wrong order? Right. So what infrastructural support do we have for the process? Now, Saudi Arabia is a very young country with about more than 70% of the population being of less than 30 years of age. So they are quite an ambitious society. And the current establishment has gone on an ambitious program to transform the society and the country. And they've envisaged it and what is known as a Vision 2030. It encompasses all walks of life in the country, and as would expect, healthcare is also a part of it. Now, the Healthcare Vision 2030 is a document that they've brought out as from the Ministry of Health as part of the Vision 2030. What the strategy envisages is that there will be new models of care program across the 6 systems of care. So if you look at the diagram on the right side, they have divided into Keep Me Well, which is essentially the primary care services. There's the planned care, there's the women and child, the urgent care, the chronic care, and the last phase. So I'm going to concentrate a bit more on what the last phase of the document says. The document envisages that the system will support patients and the families during the last phase of their lives, and it will provide them with compassionate care and empower them to spend their last days at a place of their choice. And it is envisaged that this will be brought about through family and patient support services, hospice services, and with the process of developing a multidisciplinary team involved. Now, while all that is on paper, what infrastructural support do we have? As of 2019, the document that is published by Ashamari, who's a palliative care physician in Riyadh and quite well published as far as the palliative care scenario in Saudi Arabia is concerned. He states in 2019 that there are 12 existing palliative care centers across the country, and 6 of them have been accredited from the Saudi Commission. Now, bear in mind that Saudi Arabia is a population of 35 million people and spans across 2.15 million square kilometers. So there you see that the current infrastructural support is quite minimalistic. Now, Dr. Al-Shamari has also quite nicely put or summarized the problems or the challenges faced by the Palliative Care Institute in Saudi Arabia. Now, interestingly, this gentleman is also part of the Vision 2030, the last phase aspect of the Vision 2030 of the healthcare of Saudi Arabia. So this is someone who knows quite well what the problems in the country are. So to summarize the 6 points that he's put forth, the first one is a strong emphasis on cure. So that is something that was alluded to by one of the previous speakers. So there can be a difference of understanding between the patient and the family on one side and the clinicians on the other side, that not all diseases can be cured, and sometimes the goals of care should be changed to care and not cure alone. And as mentioned earlier, there is a lack of physicians with an interest in palliative care in the country. And the third aspect is that is what is seen in a number of paternalistic societies where the patient himself or herself is not informed of the disease process. So there is a belief that mainly in the extended families that the sick person should not be informed regarding his or her terminal disease, and they would be sort of protected, in inverted commas, from receiving the bad news. So this develops a sort of distrust sometimes between the physician and the patient. The next aspect is a lack of family health services that is integrated to the secondary and the tertiary healthcare in the country. There is lack of availability of pain relief methods in that's penetrating the society. And there is also a cultural unwillingness to discuss the issues of death and dying, which is something that we see quite frequently in the intensive care. Even if the individual is on multi-organ failure, there is quite a reluctance from the next of kin to discuss regarding the death and the dying process. So this is something, there's always a huge veil for them to broach that topic. Now, I explored what published data is available from the country regarding the end-of-life and palliative care scenario. So what I did find was the end-of-life care sort of pathway was first implemented in 1992. And I did notice that the article from Lancet that came at the end of last year, wherein you could sort of take the per capita opioid use as sort of a a marker of the palliative care that the country receives. You see that for a global average of 29.51 milligrams morphine milligrams equivalents per 1,000 patients per day, which is the global average. Saudi Arabia, an individual in Saudi Arabia is about 1.24, so quite way off from the global average. So the reach of the palliative care in most of the Saudi population is very, very less. And we do find even today that the opioids and the other palliative medications cannot be prescribed by family physicians even to this day, according to law in the country. One published data that I did find from Riyadh, one of the bigger teaching institutes in the country, and this is about 10 years old, the study. They looked at their they looked at a group of about 1,000 patients over a year period in their ICU, and they found that about 176 of them died during the stay in the ICU. What they did notice was that the end of life discussions was made in only about just over 2/3, just over three-fourths of these patients. So not all patients had an end of life discussion, but what they did not comment on was whether they were unable to make those decisions or have those conversations because of lack of willingness by the family themselves. Now, for want of time, we'll look at briefly at what the challenges are. Similar to what I've mentioned previously, there are quite a number of challenges in the country regarding the palliative care setting. So one of the ones that I noticed is the social aspect, where there's a problem of mutual pretense, wherein the individual or the patient doesn't want to discuss or disclose the fact that he or she is dying or is in pain to the next of kin, and the next of kin doesn't want to discuss the dying process with the family. So there is a lot of cultural aspect within the society that is harbinger for this. That is that prevents such a discussion from happening within the society. And we discussed regarding the infrastructural and the personal problems and the legal issues. So to summarize, the country has laid down and acknowledged the shortcomings that they have got, and they've got a vision with a time frame to achieve what they want to achieve, and they are trying to implement that within the time frame that they are hoping to achieve. How do they achieve that, and at what time frames do they take to achieve where they want to achieve, what they want to achieve? That's something only time will tell. The last slide, just a perception regarding the organ donation, because that was again a side topic that was given to me. So the law of the country does mandate that anyone who is dying should, or rather I would say, if anyone is dying in the intensive care, the clinicians are mandated by law to have a discussion regarding organ donation with the family member. Now, they've got a committee called the SCOT, which is the Saudi Commission on Organ Transplant, and they've got trained healthcare staff, similar to the specialist nurse for organ donation in the UK, similar to the SNODs. And they do come along and take over the organ donation aspects if it comes to that. But what we do find is that there is a reluctance to discuss regarding this topic in the Saudi society. And I looked up at the donor rate of 2021 that's published in the IRODAT website, and compared to the world averages of 41.88 donors per million population in the USA, we've got about 3 in Kingdom of Saudi Arabia. This is as far as deceased donation is concerned. And as far as living donation is concerned, compared to the highest number of 51.92 donors per million population, Turkey, India has got, the Kingdom of Saudi Arabia has got about 37.4. So you do find that quite a lot of living donation to happen because of the lack of deceased donation within the country. Due to lack of time, I'm not exploring much more into the reasons for that, but I'll be happy to take questions during the discussion. Thank you.
Thank you, Dr. Zubair. Thank you to all the speakers for staying on and for being here for the questions from the audience. While we wait for the audience, Dr. Nagran, would you like to ask any particular question?
Yeah, I echo your thanks to everyone. I think there's been a very wide sweep of topics covered and very ambitious actually. One of the things that comes out very clearly from Dr. Mani's talk is the fact that there is still a fairly wide gulf between the narratives and discussions in those who are working in the end-of-life care circles and what is happening on the ground. And I think that's a huge gulf still in many parts of the world, especially in this country and South Asia. And that's one of the challenges, and perhaps what we see was the contrast to the UK, where I guess a lot of it has been incorporated day-to-day care. The question that always comes to my mind, again, as a practicing surgeon, especially now largely in the private sector, is how does one deal with the challenge of finances and cost as a reason or as the driver for withdrawing care? And this is a very real challenge in India. Dr. Mani referred to it, and I don't know whether some of the panelists want to respond to this, because it's a huge moral problem that sometimes we are actually withdrawing care because the family is just completely bankrupt, and that's a reality. Does one of them want to respond to this whilst we look at some other questions?
Sanjay, that is not an ethical decision. If you're making it as a basis finances, which I never do, that is, of course, one layer that is very important. You saw in the first case, it was very clear nothing was going for the patient, yet the meter was running, and yet we are not resolving the issue. That is different from a purely, cost-based decision-making in favor of withdrawal or withholding. That is not done. What happens is, if such a situation arises when the family says we can't afford to go on, and the curative treatment still has a chance, then we are either obliged to subsidize their costs. That has often happened at CMC Vellore. They publish the paper where they have the capacity to pay estimate, and a lot of them get subsidies, and about I think 1/3 of the cost is waived off in those situations. And whereas, say, another hospital like Gangaram, they converted to free. So these options are there. Or you cut out the redundant treatment modalities and investigation, which often is there. You use expensive antibiotics as a rule. 50% of expenses are in these pharmacy. So we have to look at that, revisit if you are overspending there, right? So fiscal efficient treatment is the next step, which I did a lot in Mathura. When I was in Mathura managing a hospital, fiscally efficient care could be possible. We could reduce the cost of pharmacy from 50% to 23% when we really took a critical view and then did evidence-based management. Third option is to move to a government hospital, and that we are obliged to do. What we do is generally give a case summary to the patient. If it is possible at all, we talk to a point person in the respective hospital. So we need to explore options rather than take an easy route of just doing a withdrawal, withholding. That wouldn't be ethical at all.
Sure, but what you mentioned are a few examples. The ground CMC Vellores are few and far between. But there's a question up on the chat box, and this is for Paul specifically. Paul is still there, I hope. It says medical ethics is often negated to the justice system. How does one one keep best interest as the non-negotiable? Paul, are you there?
Yes, yep, just fiddling with the mute button. Sorry, could you repeat that again? There was just a wee break in the stream. Okay,
so the question says, medical ethics is often negated by the justice system. How does one keep best interest as the non-negotiable?
Is medical ethics negated by the justice system?
Yes.
I'm not entirely sure that that initial premise is wholly accurate. I think there's a lot of cases where they do work hand in hand. We also have to be very careful when we're thinking about this here as to whether we're thinking about medical ethics or what we consider to be medical best interests here, and not necessarily conflate the two of them. Now, as I alluded to, particularly when dealing with the pediatric cases, one of the problems with this idea of best interests, when it's applied to the courts, is that there can be only one best interest. And one of the things with ethics is that we recognize that there are shades of grey. Now, that's not that I'm advocating a relativistic view of ethics in general. I still think that there might be some sort of absolute ethics. But I think with the statement itself, I think often what we sometimes think as a failure of medical ethics is actually us looking at things purely from a medical point of view, and not necessarily taking into regards the views of the patient or the views of, let's call it, the greater patient, their sort of psychological, social, and family interpretations of things. I mean, it's interesting listening to what some of the speakers had said. I think somebody quoted from the Archie Battersbee case to say that there should be no distinction between legal practice and good medical practice. And I think that's true, but I think we've got to remember that that is good medical practice and not just medical practice as a whole. If we think about some of the big things outside of end-of-life care that have really changed UK practice, we could think about the Montgomery decision when it comes to consent. And what did that do? Well, that actually empowered patients. It stopped us thinking about what the doctor would want to tell patients about. It moved even beyond thinking about what this fabled objective patient would want to hear about. And it talked about the subjective patient, the patient in front of you. And therefore, if we're going to talk about good medical practice is patient-focused, and it's focused on the patient in front of you. And I think that is what the courts are trying to capture. And therefore, to say that there's a deviation between medical ethics and legal practice, I don't think that's necessarily the case. I think what we need to be clear on is that we should all be working towards the benefit of the individual in front of us. And sometimes that means we have to look beyond our own medical expertise. And like was highlighted by Devani, this whole idea of what is the role of the courts themselves. And it's probably as some sort of third person arbiter. Is there a better way than best interests? Well, there might be, in a way that recognizes shades of grey and shades of reasonableness. But I think there isn't actually, when you take good medical practice that's patient-centered, I don't think there should be that much difference between medical ethics and courts' decisions.
Thank you, Dr. McConnell. There's a question, and I think I'd like to ask Dr. Vidya Vishwanath that. Oh, you've already written it?
Yeah,
Okay.
because I just thought it would save time.
Okay, then I have a question for Dr. Salins. Dr. Salins, there is a book by Catherine Mannix, which is called With the End in Mind, where it says it has become taboo to mention dying. Euphemisms like past or lost have replaced died and dead. Illness has become a battle, and sick people, treatments, and outcomes are described in metaphors of warfare. And Dr. Mani referred to this. So we talk about people losing the battle, even if they've lived a very, very good life. Reclaiming the language of illness and dying enables us to have simple, unambiguous conversations about death, is what she says. How do you think we can do this in our communities, reclaim these conversations and spaces, and what kind of vocabulary should we use?
Okay, so vocabulary is always at play. If you see, it started as a hospice. Hospice became palliative care. Palliative care became supportive care. Now they call it as quality of life service. So hospice was equated to death and dying. Later on, palliative care became equated to death and dying. Supportive care became equated to death and dying. So it's not the words probably. It's how you present it or how you package. Or that's so. I feel that we need to be very realistic. So my department is still called Department of Palliative Medicine. Yeah? And I clearly tell that what is the scope of my services. It's not the blind man going and seeing the elephant and perceiving it as something, and a lot of them still perceive it as an end-of-life care service. But once you engage and work with various, at least my oncologists clearly know what palliative medicine or palliative care stands for. I feel that it needs a lot of that close association and working for someone to fully realize and understand the scope of service. If you allow me, there was a question that was sent to me as a direct message by Shankar Nagesh, asking whether end-of-life care at home is allowed in India. I'm sure it is allowed, and it's just an extension of palliative care, home-based palliative care that is already being done, where we provide an end-of-life care at home, and it's definitely being done. And he has asked how it is being done. As I told, end-of-life care is just a continuum of palliative care, and we prepare the family for the person to die at home. We ensure that the necessary drugs are made available in some form. We also ensure that the medical support that is needed at that point of time is being made available. Thank you, Sumana, for the time.
Thank you. I think in the interest of time, I'm so grateful to all the speakers and the audience for staying on for really this very extended session. So in my little brief vote of thanks, I'd first like to thank all the speakers, Dr. Paul McConnell, Dr. Radha Sundaram, Dr. R.K. Mani, Dr. Naveen Salins, Dr. Dwani Mehta, Dr. Zubair, and did I mention Dr. Vidya Vishwanath? Yes. Thank you, all of you, for readily agreeing to be a part of this webinar and for all your thought-provoking presentations. A special thanks to Radha for bringing Dr. Paul McConnell on board and for her unstinting support. I'd like to thank the Department of Medical Humanities, Dr. Lopaben Mehta and Dr. Padmaja Samant Mavani for being co-hosts for this. I'd also like to thank Dr. Vijay Prasad Gopichandran, Department of Community Medicine, ESIC Medical College, Chennai, and working editor of the IJME for his practical guidance. I'd like to thank the FMES team, Vijay Savant, Dr. Sharanya Srikumar, and Mahindra Shinde for their administrative and tech support. Thanks to my co-moderator, Dr. Sanjay Nagral, for his critical insights and astute analysis as always. And my biggest thanks to Dr. Sunita Sheel Bandevar, General Secretary, FMES, Director, HEAL Institute, and working editor of the IJME for her encouragement and her constructive inputs from start to finish. I would not have done this without you, Sunita. Thank you. And finally, thank you to each and every member of the audience, especially the ones who've stayed on for this long, for being here with us this evening. You brought the webinar to life. Thank you and goodbye.
Goodbye. Bye-bye.
Bye.
Bye.